Nobody wants to mess with Uncle Sam. Under certain circumstances, you must comply with U.S. export control regulations, even outside the United States. In export controls, there's probably no area that's more intimidating for businesses. That's why in the upcoming videos, we'll be taking a closer look at the Made in USA regulations. Then you'll be fine dealing with the Americans. My name is Ulrike. I'm an attorney at AEB. And I know the US re-export control regulations like the back of my hand. In my videos, you'll find practical tips tested in real-world scenarios, and some elements were created using AI. Can you imagine that right at this very moment, employees over in the US are watching videos about how the EU's export control regulations are structured and implemented? In my seminars, that's always the first thing that gets a laugh. Somehow, it's almost unimaginable the other way around.
But what are the differences in export control law?
Unlike the EU, the US has designed its export control law to be extraterritorial. Extraterritorial, not extraterrestrial. What does that mean? Extraterritorial means the US asserts the applicability of its laws beyond its own national borders. So, under certain circumstances, US export control regulations must also be adhered to outside the United States. In Djibouti, the Dominican Republic, and Germany, the determining factor is the concept commonly referred to as re-export. Re-export from a US perspective is a shipment from one third country to another third country. So, for instance, from Germany to Austria, but also from China to Russia.
Why is the US even doing it like this?
The reason are national security interests that the US wants to protect through these regulations. The main aim is to prevent US-made products and technologies from ending up in the wrong countries or in the wrong hands. And what counts as wrong is defined by US regulations and policies.
Do I really have to follow their rules?
Individuals who fail to comply may be subject to sanctions by US authorities. That means a hefty fine, and if a company refuses to accept it, it ends up on the denied persons list or the entity list, effectively cutting it off from trading with US products. That's, well, let's just say it's almost always really bad for your company.
But who is responsible for all this?
The authority in charge is the United States Bureau of Industry and Security, in short, BIS. It is responsible for overseeing and ensuring compliance with the EAR, the Export Administration Regulations. This makes the BIS the official licensing authority for exports and re-exports of civilian US products. Fortunately, companies outside the US only need to comply with the EAR for specific transactions.
And how should I know what to decide?
To help companies navigate the requirements more easily, the EAR include a so-called decision tree. Easier is kind of relative because they start right away with many paragraphs. But that's exactly what we're going to look at step by step. Question 1.
Are your items and activities subject to the EAR?
The US export control regulations have two key criteria. First, activities of US persons, and second, trade involving civilian US products.
Who does actually count as a US person?
According to Section 772.1 of the EAR, this includes every US citizen and every permanent resident, particularly green card holders. Individuals who, regardless of their citizenship status, have established their primary residence in the US. All individuals currently present within the US, along with any legal entity organized under US law. So, the last point is naturally the most interesting one. Only US corporate forms such as an Inc. are considered US persons under this definition. A GmbH or an SE or GmbH and Co. KG or an AG, therefore, do not qualify as US persons under the EAR.
And what about those Americans who work, for example, in a GmbH?
Yes, I get that question often. And yes, while they are US persons under the EAR, They don't act as contractual parties in B2B transactions. The contracts are always concluded between two companies, so the EAR doesn't apply, even if the managing director of the GmbH is an American citizen. For companies outside the US, the key question is, do I have US products in my inventory? In episode 2, we'll take a detailed look at product-related criteria and how to manage them effectively and smoothly without ending up with a headache. So make sure to subscribe to the channel, and I'll see you soon for episode 2. And if you have any questions, feel free to leave me a comment.